subject to the discretion of the Honorable Judge. Each team shall intimate the court master, me, in regard to the division of time between the speakers. Only one speaker from each team shall be permitted for the rebuttal and surrebuttal. Else it is on the discretion of the Honorable Judge. So I may now proceed with the order of presentation, which is first, Speaker 1 of the petitioner, then Speaker 2 of the petitioner, then Speaker 1 of the respondent, then Speaker 2 of the respondent. I will repeat again, the order of the presentation is first the Speaker 1 of the petitioner side, then Speaker 2 of the petitioner side, then Speaker 1 of the respondent side, same Speaker 2 of the respondent side. Then rebuttal from the petitioner's side first. Any one of the two speakers is allowed for the rebuttal. Then surrebuttal from the respondent side. Any one of the two speakers are allowed. Surrebuttals will be permitted only at the discretion of the Honorable Judge. The judges may exercise discretion for extending the time for the oral rounds beyond the time, as specified in the rule book. The rule book provides the time extension up to 2 minutes, which is permissible for each round. To ensure the clarification, the team code for the petitioner is team code 17. The team code for the respondent is team code 68. If taken time for rebuttals, we mention that in case of extra time is being taken before the commencement of the round, the total time will be 50 minutes, 50 minutes, with petitioner 1 speaking for 10 minutes, then speaker 2 from the petitioner side speaking for another 10 minutes, whereas the respondent speaker 1 presenting their arguments for 10 minutes and respectively same for speaker 2, which is 10 minutes. And 5 minutes will be given for rebuttals. I now would like to seek the permission of the bench to start with the proceedings.
Kindly proceed.
Thank you, Lordship. Much obliged. I now request the petitioner side to start with the proceedings. Thank you.
Greetings, my lord. My lord, the counsel for the petitioner seeks your permission to address this court.
Kindly proceed.
My lord, if it pleases the court, may I take a brief moment to acquaint the court with the facts of the case?
Please.
My lord, the ancient Bake Bihariji temple in Vrindavan stands as one of the India's most sacred temples, welcoming over 50 lakh devotees annually within its historically evolved heritage precincts of devotional pathways and century-old structures. Following the tragic stampede on 19th August 2022 during Janmashtami, which resulted from inadequate crowd management, PIL proceedings under 226 were sought and judicial intervention for the devotee safety was granted. The state's response was an ambitious Bake Bihari Temple Corridor project, which proposes comprehensive demolition of over 300 heritage structures across 8 acres of historically significant. My lords, the Allahabad High Court's directive on 20th March of 2023 mandated project execution, emphasizing public safety, and this has triggered this constitutional challenge, which is the present SLP, my lord. My lord, the petitioner, MX Govind Das, represents hundreds of displaced families whose fundamental rights under Article 14, 21, 25, and 26 face imminent violations, my lord. My lord, this case concerns constitutional protection of heritage, environment, and fundamental rights, also disproportionate state action, which has been masqueraded as public safety, my lords. With this, my lords, I'll take the permission of the court without wasting much time to directly move towards the first issue.
Can you proceed?
Much obliged, my lord. My lord, the first issue of contention is that whether the validity of the issuance of mandamus with respect to Article 226 of the Indian Constitution is valid and whether the issuance of such writ constitutes micromanagement. My lord, at the premise of petitioner's argument is the assertion that by the issuance of such writ, the court has vehemently ignored the constitutional framework which enshrines separation of power as an unavoidable feature under the basic structure doctrine, my lord. My lord, this was also firmly established in Keshwananda Bharati versus State of Kerala and something that is also established by the virtue of Section 50 of the Constitution, my lord. My lord, Article 50 mandates separation of judiciary from executive in public service and policy matters, my lord. My lord, this creates an indispensable autonomy that cannot be abrogated through constitutional amendments, much less through judicial direction, my lord, which is what has happened in this case. The constitutional scheme, my lords, envisages a threefold division, which we all are well aware of. The executive formulates and implements policy, while the judiciary exercises review without usurping the executive's function, my lord. My lord, infrastructural development, urban planning, and crowd management thus fall squarely within executive's constitutional domain. My lord, while Article 226 indeed confers wide, broad powers, these powers are not unlimited. The Supreme Court in West Bengal versus Commissioner for Protection of Democratic Rights has clearly held that the Article 226 powers must be exercised within constitutional limits and cannot transgress the federal structure or separation of power. This distinction, my lord, lies in the nature of the direction which has been issued in the case. Courts can set outcome-oriented safety standards and annul illegality, but cannot substitute their judgment for executive policy formation, which this case is an example of. My lord, courts must exercise judicial restraint in this case and refrain from encroaching upon executive or legislative domains. My lord, the Supreme Court has consistently affirmed that courts cannot issue mandamus, compelling the state to frame a certain kind of policy. My lord, I would take the chance here to make this clear that we are not against the court issuing the writ, but the nature in which the writ was issued. My lords, this writ has basically became an example of the court hand-holding the state to only issue a certain corridor scheme, my lord. My lord, the Supreme Court has jurisprudentially proven that the court cannot issue mandamus compelling the state to frame a certain kind of policy, whereas executive decisions concerning policy formation and resource allocation are answerable through democratic processes, which is my vote, my lord. My lord, judicial substitution erodes this democratic principle that policy choices are determined by elected representatives, either them or their appointed authorities, my lord. My lords, I would like to ask the court if they have any questions at this point, or I'll move on to the second issue of contention, my lord.
Kindly proceed to the second issue.
All right, my lord. Much obliged. My lord, the impugned order, as the council of respondent, I contend that the impugned order directing reconfiguration of temple approaches, alleys, and religious circulation routes constitutes a grave violation of 25 and 26 of the Constitution, warranting immediate intervention by this honorable court, which is the matter of this SLP. My lord, 25 and 26, as we all know, guarantee religious freedoms as lived faith, encompassing rituals, observances, ceremonies, and modes of worship that are essential to the community. My lord, the Supreme Court in the Shiruri Mutt case affirmed that matters of religion encompass doctrine, dogma, bhakti, and karmkands, bringing communal practices within Article 26B's ambit of denominational management protection, my lord. My lord, the case that I just stated also crystallizes the essential practice doctrine, stating that a ritual is essential if religious nature would be altered without it, forming the belief and worship's keystone, my lord. My lord, this doctrine was denominations, which is the temple administration in this case, with exclusive authority to identify indispensable rites and ceremonies for scriptures, traditions, which are immune to external displacement, my lords, and their absence in the decision-making process clearly contravenes that. My lords, traditional temple approaches and circulation routes meet the essential criteria because this rests on the significance of them, which is proven by the people's belief that have been continuously observing these alleyways as sacred for centuries. My lords, it is believed that in the alleyways which the court in this case is proposing to reconstruct, Lord Krishna did his Ras Leela and lost his heart. The Supreme Court, my lord, recognizes that entire temple precincts must be held sacrosanct in other judgments as well, my lord, which are the part of our compendium, wherein well-established Hindu temples, temple worship precincts essentially exist with agamic backing, my lords, which is the people's belief. Therefore, my lord, traditional temple circulation routes qualify as integral religious practices, forming settled worship patterns under 25.1, my lord. Therefore, my lord, the proposed reconfiguration fundamentally interferes with this by altering traditional sacred spaces and alleyways, essentially. And this reconfiguration, my lords, contravene the religion's freedom, which encompasses all acts done in pursuance of religion and the constitutional assurance that religion may be practiced anywhere. State interference in religious affairs faces strict constitutional limits, my lord, under Article 25 and 26. Intervention in such cases require clear demonstration that denominational rights threaten public order, morality, or health, my lord. This high threshold, my lord, is the compelling interest before any constitutional intervention in such religious practices. My lords, again and again stating that regulatory powers must not duly infringe protected freedom or amount to previous and absolute restraint on religious expression, which is also what the case of Vijay Emmanuel versus State of Kerala has held. My lords, additionally, where less restrictive alternatives achieve the legitimate state objective, constitutional principle require their adoption over intrusive measures which have been implemented in this case already. My lords, it is a matter of both constitutional and administrative law which mandates less restrictive alternatives when limiting or contravening the fundamental rights by the state. My lords, where crowd control, enhanced security protocol, or a phased access system can provide the same results, the counsel for the petitioner does not see a need for the demolition of these structures, my lord. My lords, religious rights require procedural protection through meaningful consultation and participatory decision making, is which is a principle of not only jurisprudence but a principle of common sense, my lord. Absent such consultation, my lord, denominational and absence of denominational involvement in reconfiguration of the routes of these alleyways also violates the principles of natural justice, my lords, which are the governing factors of our fundamental rights. My lords, the state's unilateral reconfiguration therefore transgresses constitutional guarantees of freedom by irreversibly altering essential religious practices and encroaching upon denominational management rights without satisfying the standards of necessity, proportionality, and least restrictive measures, my lord. It is respectfully submitted to this honorable court, my lord, to set aside this impugned order and direct the state to adopt less intrusive measures that preserve the constitutional and religious freedom while
Sorry for the
addressing
interruption,
legitimate safety concerns.
but 10 minutes are
My
already
lord,
over.
at this point, I would like to ask if the court has any questions, my lord, towards my submission. Otherwise, my submission for issue 1 and 2 ends here, man.
Yes, sir.
Speaker number 2 for the petitioner, please.
So I would request the court's permission to get started with the third issue.
Please, please,
Much
Ms. Counsel,
Your
proceed.
Honor. The counsel for the petitioners would like to submit that the state's objectives of crowd management and public safety do not justify the large-scale demolition and redesign of organically evolved sacred precincts, since less restrictive alternatives are effective. My lords, the Banke Bihari Temple precinct is an organically evolved cultural and spiritual space shaped by centuries of continuous religious practice, traditional lifestyle, and community interaction. The loss of such organically evolved heritage precinct translates into an irreversible cultural depreciation, and the state has an obligation to safeguard them, recognizing them as critical to the environmental, cultural, and spiritual well-being. The right to life under Article 21, my lords, encompasses not only physical survival, but also the right to live with dignity. This extends to the protection of cultural heritage and traditions integral to human identity and societal values, thereby acknowledging that depriving citizens of their cultural environment undermines their fundamental rights. The Supreme Court, in the case of Consumer Education and Research Center versus Union of India, has observed, and I quote, "The right to life with human dignity encompasses within its fold some of the finer facets of human civilization, which makes life worth living. The expanded connotation of life would mean the tradition and cultural heritage of the persons concerned." End quote. In the current proposed project, the state risks eroding centuries-old tradition architecture and the socio-economic fabric of the city of Vrindavan, which shakes the mere foundation that supports the pilgrimage economy. Moreover, any deprivation under Article 21, my lords, must follow a procedure that is just, fair, and reasonable, as held by the court in Maneka Gandhi versus Union of India. The indiscriminate demolition with inadequate consultation or rehabilitation violates this procedural mandate, and the state cannot prioritize infrastructural redesign without first ensuring that the heritage considerations and cultural rights are balanced and preserved. Additionally, religious freedoms can only be restricted by public order, morality, and health, and require strict, narrow construction. The physical site and architecture of worship are integral to these rights, and arbitrary state interference is strictly forbidden, as stated in the Shirui Mutt case. There is no automatic priority between public safety and religious or cultural freedoms. The court requires independent justification in every restriction and must harmonize to maximize the utility of the limitations imposed. Further, the four-pronged proportionality test, as laid down by the Supreme Court in the case of Modern Dental College and Research Center versus State of Madhya Pradesh, requires administrative actions that limit fundamental rights to 1. Serve a legitimate aim, 2. A rational nexus between measures and that aim, 3rd. Necessity with regards to use of the least restrictive and equally effective alternative, and 4th. Balancing and proportionality between the rights cost and public benefits. The state, my lords, in the present case fails this test, as less restrictive alternatives would achieve the same required objectives. The state has failed to show that demolition is the only way to ensure safety, given the successful non-structural crowd management methods at other religious sites. Examples of this include, my lords, the Tirupati temple in Andhra Pradesh, where they successfully managed 75,000 daily visitors with online tokening systems, RFID, which is radio frequency identification enabled tracking systems, and CCTV monitoring. Similar technologies are also implemented in the Mata Vaishno Devi temple and the Sabrimala temple, that too without structural changes. The Supreme Court has proscribed arbitrary demolitions, and state must observe strict adherence to due process, which is mandatory before any demolition, especially in sacred religious spaces. Legislative safeguards like the Ancient Monuments and Archaeological Sites and Remains Act of 1958 and judicial precedents like the Shiruri Mutt case provide a special protection to religious institutions against arbitrary or disproportionate state interference. As previously submitted, minimally intrusive crowd management solutions such as AI-powered crowd density monitoring, RFID tracking, online darshan booking, and real-time updates offer comprehensive safety without demolition. If I may have the permission of the court to move on to the fourth issue.
Yes, Ms. Counsel, you can. But I have a question for you, Ms. Counsel.
Much
My question is,
yes, sir.
if the state proceeds with online structuring of the lines and the darshans of the religious devotees, then it will interfere with the Article 25 of your own petition.
I request a bit of elaboration on the same, my lords. I don't completely comprehend.
If the state comes with the issue proposal that you are lying with, you are stating that the darshan lines can be queued, token system can be given, but it will go against the faith of the people, the religious devotees in the area, and they will protest in that case.
My lords, it is submitted that such practices have already been adopted in multiple temples and religious sites all over India. So there is a proven precedent that this does not infringe or will not amount to any backlash from the public or infringe on their rights under Article 25.
But there will be chances of backlashes from the public.
My lords, there is public backlash in the current proposal as well. And these measures, which are non-intrusive and least restrictive, are also ensuring that other rights, such as the rights under Article 21, are not infringed.
But Article 21 is firstly, we should give reference to life. And it was a stampede on 19th of February. 19th of August 2022, after which the state come up with a proposal of redevelopment. So
My lord,
we
stampede
shouldn't give
occurred.
a preference to the life of a person. I will come to you, the speaker one.
My lords, there needs to be a proportion and balance between the rights conferred under Article 21. There is no absolute automatic priority given to one right over another. The mass
Okay,
stampede
let's
is a
proceed with issue 4 now.
much obliged, Your Honor. It is humbly submitted that the absence or inadequacy of public consultation renders the decision-making process arbitrary under Article 14. As previously mentioned, the right to life enshrined under Article 21 is a holistic right that goes beyond physical survival to include dignity, livelihood, shelter, and cultural rights. The right mandates that no individual shall be deprived of life or personal liberty except by procedure established by law that must be fair, just, fair, and reasonable. Article 21 is intrinsically linked to Article 14, which guarantees equality before the law and prohibits state action. Article 14 has evolved to impose a broad prohibition on arbitrary decision making that affects fundamental rights. And therefore, the absence of meaningful public consultation with affected parties renders the decision making process arbitrary and unconstitutional under Article 14. Moving on to the arguments per aggrieved party that were not heard in the decision making process, we first submit on behalf of the residents and shopkeepers. The forcible eviction of over 200 families and displacement of around 500 small businesses without fair compensation or a prior hearing contravenes with statutory safeguards of the LAR Act, which require transparency, participation, rehabilitation, and resettlement before the acquisition or eviction. Proceedings against properties with informal, customary, or disputed titles, out of which there are many under the current acquisition plan of the project, without prior judicial adjudication, violates Article 300A's due process guarantee. The question of land ownership cannot be determined unilaterally by the authorities. This principle was stated in the court by the court in the case of Ganesh Burman versus State of Jharkhand, where it was said that the doctrine of separation of powers mandates adjudication of ownership must be done before by the court before acquisition is made. In the recent Supreme Court guidance in the case of Kolkata Municipal Corporation versus Bimal Kumar Shah reinforces that deprivation of property must be met with procedural safeguards, namely the right to notice, hearing, reasoned decisions, acquisition which is strictly for public purpose, fair restitution and compensation, and a timely, efficient process prior to disposition, none of which were observed by the state in the present matter. Moving on to the concerns of environment.
Sorry for the interruption, but your time has already ended.
May I request?
Speaker 2, we will get back to you later. Coming to
Okay,
speaker
Mr.
1. You would like to answer the question of the personal right to life on the prospect of Article 21. So, the right to life should be prioritized in this case, or the Article 25 should be prioritized in this case.
Certainly, my lord. My lord, before that, I would like to thank you for the
Because
opportunity.
it will if we give prioritize the Article 25, it will one on the other side, it will hurt the fundamental right and the religious obligations of the devotees. It is going to hurt. But
Certainly.
we cannot deviate with the stampede of 22.
Certainly, my lord. My lord, firstly, I would like to thank you for giving me the opportunity to answer this question on behalf of respondent 2. My lord,
Just mention 2 minutes for you, Mr. Counsel.
Thank you so much, my lord. Much obliged. My lord, the court's duty is to protect 21 is undeniable. We are not denying it. But the method in which it is done matters, my lord. My lords, this court in the case of Ram Java Kapoor versus State of Punjab recognized that executive's inherent power is not policy formulation, my lord. My lords, in a case where the Allahabad High Court would have directed the government to come up with a scheme in itself to protect Article 21 of the devotees after the stampede, we would have accepted the assessment, my lord. But my lord, my main contention is that in with respect to mandamus, the court can tell them to do their public duty, tell or direct the state to do their public duty, but cannot say how to do it. My lord, it can again suggest ways to do it, but in this case, my lord, the court has held the hand again of the state to make them propose a corridor scheme. And my lord, when it comes to whether we should prioritize Article 21 or 25, my lords, I think we should prioritize neither, because both of them are fundamental rights, both of them have an equal status. And my lords, in my personal opinion, which is not constitutionally or
Sorry for
jurisprudentially
the
bound,
interruption,
I would
but the
say
time
I
is
would say that they should prioritize 21, but my lords, 25 should also be prioritized, and 21 could have been prioritized, my lords, in a way where shopkeepers, environmentalists, the people who have been dislocated would have been consulted. My lords, in that case, they would have, even if they would have proposed the corridor scheme, my lords, there would have been a better outcome, because these people would have then not shown their retaliation in this case, my lord. My lord, that is my humble submission.
It's okay. We will get back to you in rebuttal now. Team TC 68 for the respondent. Your arguments now, Speaker 1.
Lordship, am I audible?
Yes, you are audible.
The council seeks permission to address the bench as your lordship.
Permitted.
Much obliged. May it please your lordship, the council is appearing on the behalf of respondent in the case Govind Das and others versus the state of Uttar Pradesh and others. If your lordship allows the council seeks permission to proceed with the statement of jurisdiction.
Proceed.
Highly obliged. The petitioner Govind Das and others invoke the esteemed appellant jurisdiction of this case under Article 136 of the Constitution, form of a special leave petition in Honorable Supreme Court of India. The Honorable Supreme Court of India, having possessed jurisdiction under this Article 136 of the Constitution, as it is the court of the first instance empowered to entertain special leave petition of this nature and value, and therefore the competent to grant appropriate relief in the favor of justice, equity, and good conscience. If your lordship is satisfied with the statement of jurisdiction, the council seeks permission to move statement of fact.
But Article 226 do not have a scope. The High Court cannot intervene with the executive provisions, Mr. Counsel. And as per the claim of the petitioner, the High Court has intervened, invoking Article 226, intervened with the procedure of the executory and administrative procedures. The state cannot be allowed the court cannot be allowed to dictate the state. The state has there is own jurisdiction and administrative framework.
I humbly submit Article 226 empowers the High Court to issue writs not only for the enforcement of fundamental rights but also for any other purposes. This wider power allows intervention when systematic executive failure endangers the public safety. The state's duty to protect citizens at place of worship was neglected despite recurring stampede and overcrowding. Thus, the court writ of mandamus was necessary to compel performance of this public duty.
Okay. But public duty it is a duty of the state, not the court.
But sir, in this case, in this matter, it is found that Article 21 is an absolute in nature.
The stampede, the public duty, it is the duty of the state to protect the citizens of the state, to enforce law and order, not the court to direct the state.
Indeed, your lordship. But the in our country, judiciary is independent. It can check accountability and even issue the guidelines. But where there is a case of intervention, when the executives are not working proper well, there is a jurisdiction in Article 226 that they can they can issue writs. That's why they are in their jurisdiction of allowing under Article 226.
But this is not a suo motu writ, Mr. Counsel. This is a writ filed by the petitioners itself.
There is a concept, sir, of judicial activism. May I present, sir? The council
Yes,
needs
please.
more to elaborate the judicial activism point.
Please.
The High Court section fits within the tradition of judicial activism, where courts have stepped in the remedy execution when the execution is inactive. There is a case in Vishakha versus State of Rajasthan. This court led that the workplace safety guidelines in the absence of legislation. Likewise, the High Court acted here to protect lives threatened by repeated failure of the executive. Even there is a record that 2 lives were finished and several were injured. So the council still upholds that the intervention was by law.
Okay. Coming to the issue number 2.
Indeed, Your Lordship.
If your lordship is satisfied with issue number 1, the council seeks permission to proceed with issue number 2.
Sure. The
So, much
Speaker,
obliged, Your Lordship.
you will address all the further issues now?
Indeed, your lordship.
Sure. Okay, proceed.
Your lordship, basically the issue number 2 deals with, does changing the temple's layout interfere with religious freedom under Article 25 and 26? And if so, what's the test for distinguish helpful state action for unconstitutional interference? Your lordship, the state of Uttar Pradesh stands firm in its conviction that the Baki Bihari Temple Corridor project is a legitimate and lawful exercise of its constitutionally and statutory authority. This project is not an act of constitutional interference, but an imperative act of constitutional duty. It is a secular act of urban planning and crowd management, a direct and necessary response to paramount need for the public safety, health, and order. Your lordship, the challenge before this honorable court is to distinguish between the faithful facilitation and the unconstitutional interference. The key lies in the doctrine of essential religious practices and the explicit limitations placed on religious freedom. Your lordship, Article 25 and 26 protect practices that are essential and integral to a religion. The seminal case, like Shri Moot and Durga Committee, permit the state to regulate economic, financial, political, or other secular activity which may be associated with the religious practices. Your lordship, the state is not seeking to alter the core spiritual act of darshan, which is the religious practices. We are addressing the secular aspect of the pilgrimage, the congested lanes, the lack of proper ingress or egress, and the absence of emergency services. Your lordship has affirmed in Sri Adi Vishwara, the regulation of administration and management are secular functions. We are simply making the physical environment safer and dignified for all devotees to practice their faith. We are facilitating worship, not interfering within it. Your lordship, the rights guaranteed under Article 25 and 26 are explicitly subject to public order, morality, and health. The stampede of August 19, 2022 is irrefutable. Tragic evidence that the existing infrastructure possesses a grave threat of human life. The right to safe a pilgrimage is an essential facet of the right to life under Article 21. The state has an affirmative duty to protect the human life. This duty cannot be held hostage to claims of preserving a dangerous urban layout. As held in Durga Committee, no religious practices that is a danger to public safety can be protected under the guise of religious freedom. Our action is a reasonable and proportionate restrictions undertaken to uphold the most fundamental of all rights, that is right to life. Your lordship, furthermore, the Baki Bihari Temple Corridor project is a constitutional imperative, a tangible act to promote the welfare of the people. It is in direct fulfillment of the directive principle of state policies, particularly in Article 39, Clause B of the Constitution of India, which mandates the state to ensure that material resources subserve the common good. We are enhancing the public rights to clean and safe the environment, which the Supreme Court has interpreted as the part of the right to life under Article 21 in concerns with the state's duty under Article 48A regarding property, the right has moved to under Article 300A of the Constitution of India. The state's acquisition of land is conducted strictly according to the procedural established by law to maintain public order and morality. Finally, Your Lordship, the project has been implemented in strict adherence to the LARR Act of 2013 with the land acquired for a clear public purpose. Far from damaging ancient monuments, the project is planned to enhance their preservation and accessibility in full consonance with Article 49. The state is not violating the religious freedom. It is upholding its paramount duty to protect human life and promote the public good. We are not intervening in the faith. We are creating a safe passageway for its flourishing. Your Lordship, the project is a secular, proportional, necessary, and legal sound. We urge this Honorable Court to affirm state's constitutional right to protect the lives of citizens. That I humbly submit. If the Lordship is satisfied with issue number 2, the Council seeks permission to proceed with issue number 3. Indeed, Your Lordship.
Proceed.
Your Lordship, issue number 3 basically deals with does the government has to knock down and rebuild the old temple area for safety, or should they try smaller, easier fixers first? Your Lordship, the Council humbly submits before this Honorable Court, Supreme Court of India, that the state's objective of crowd management and public safety anchored in Article 21 of our Constitution justified the large-scale demolition and redesign of the organically evolved sacred precinct. This action was not a choice, but a constitutional necessity taken only because less restrictive alternatives were demonstrably insufficient to meet a continuous and imminent threat to human lives. The state argues that its actions are necessary and proportionate response to a grave public safety hazards. The proportionality doctrine, a cornerstone of our jurisprudence, demands that any state action restricting fundamental rights must be the least restrictive means to achieve a legitimate aim. While the petitioner may argue for least restrictive alternatives, the state solution must be judged against the imminent and continuous threat to the lives of millions of pilgrims. Your Lordship, the right to life under Article 21 of the Constitution of India is the fundamental and absolute of all rights, and the state has a primary and affirmative obligations to protect it. Your Lordship, the tragic stampede on August 19, 2022 was not an isolated incident, but a foreseeable consequences of the inadequate infrastructure. Your Lordship, the state's action therefore is not an arbitrary choice, but a necessary measure to prevent a recurrence. The state must act to prevent the loss of lives, a duty that supersede all other considerations. Your Lordship, the proposed corridor is not merely a convenience, but a vital public utility essential for ensuring a safe and dignified pilgrimage. Your Lordship, the petitioner suggested such alternatives, such as staggered darshan and technological advancement and technological enabled flow, are fundamentally insufficient to address the core problem. Your Lordship, Vrindavan's pilgrimage economy is largely informal and unpredictable, making a token-based system difficult to implement and enforce for millions of pilgrimage. Furthermore, during major festivals like Janmashtami and Holi, the sheer volume of the pilgrims makes such measures ineffective. The physical limitations of the narrow lanes and lack of emergency access cannot be solved by the administrative and technological fixes alone. Your Lordship, the only suitable and effective solution is the fundamental change to the infrastructure to accommodate the crowd safely. The state has a duty to provide a long-term sustainable solution because salus populi is the suprema lex, which means the welfare of the people is the supreme law. Your Lordship, the state submits that the right to life takes precedence over the petitioner's claims to right to livelihood, property, or the preservation of the specific urban layout. Your Lordship, the Honorable Supreme Court of India in the Olga Ellis versus Bombay Municipal Corporation, where the Supreme Court recognized the right to life, right to livelihood as a part of Article 21. This right is not absolute. It can be subjected to the reasonable restriction in the interest of public safety and a larger public good. Your Lordship, the state's project aims to secure the lives of millions of devotees, which is a greater public good than the livelihood of the few hundred individuals. The state has also planned for the compensation and rehabilitation, demonstrating its fulfillment of the constitutional mandate under the directive principles of state policies under the Constitution of India, which is provided Article 37 are the fundamental in the governance of India. A policy that restricts fundamental rights for the purpose of fulfilling DPSP is inherently more likely to be considered reasonable restriction. This project aligns directly with the several critical DPSP like Article 48A of the Constitution of India and the 49 of the Constitution of India. Your Lordship, if I am talking about the LARR Act, which provides the full compliance with all relevant legislation. Furthermore, this project consents with the AMASR Act also. Under Section 20A of LARR Act, which provides the explicit statutory authorization for the state's action by allowing public work in prohibited area to enhance to protect the monuments. Your Lordship, if I'm talking about some examples,
Sorry for the
also,
interruption. Your time has already ended up.
indeed, sir.
Please.
If your Lordship is satisfied with issue number 3, the Council seeks permission to proceed with issue number 4.
Council, we will take up at the time of rebuttal in that case. As
Indeed,
your
Your Lordship.
time, as
Indeed,
your
Your
time is
Lordship.
over, we will take up with the rebuttal.
Indeed, Your Lord.
Petitioner's rebuttal now.
My lords, if I may proceed.
Please.
My lords, my first rebuttal is towards the first counsel of the respondent. My lords, the council talked about judicial activism, but I agree with, in this case, let's say I agree with the council of respondent that not even talking about judicial activism, we can say that 226 grants the court the expansive power to issue such writs. My lords, but what about the judgment of West Bengal versus Commissioner of Protection of Democratic Rights, which I continuously stated in my submission, which clearly states that Article 226, although grants the power to issue expansive writs expansively and for any other purposes, which is also the text of the article, but it cannot hold the hand of the state to compel it, to supplement it, to only enact one policy. My lords, the distinction here lies in the nature of the direction, which is not addressed by the council of the respondents, which I would like them to do right.
Okay.
If your Lordship allowed, the council wants to answer the question.
Later on, Mr. Council. Let the petitioners first complete their rebuttals.
My lords,
Indeed.
the second rebuttal that I have is towards the very insensitive statement that second counsel for the respondent had stated that it is only about the livelihood of a few hundred people. My lords, as I continuously stated that there is no hierarchy of fundamental rights requiring one to trump the other. Both 21 and 25 and 26 are fundamental rights that require harmonious interpretation. My lords. The constitution permits regulation of public order. Yes, it does in 25 and 26 themselves. However, such regulations must satisfy the constitutional test, which is compelling state interest. Second is of proportionality. And third is of the least restrictive means, which we continuously stated in our submission. My lords, the state can ensure safety through crowd control protocols, which also were shown in our submissions by examples, which have been effective. So, in that case, my lords, what ways can the second council of the respondents would technically give so that the state can provide adequate compensation to these 100 people, and can even adequate compensation be provided considering that these people had a right over their land? That is my humble submission.
Okay. Speaker 2. Speaker 2, your rebuttal.
Yes, Your Lordship. So, Lordship, my first rebuttal would be that on issue 4, section 20A of subsection 4 of the AMASR Act bars granting new permissions except through central government or Director General of the Archaeological Survey of India for construction work in prohibited zone, which is 100 meters from a protective monument. So I would like to ask the counsel for the respondents to please suggest how they can bypass this particular mandate in the AMASR Act and continue with the project without prior permission from either of these parties, as in the case of Nahata Traders and Builders Private Limited versus Director General of the ASI. The courts have said that strict procedure compliance must be made, and a court order in replacement of a direction from the central government or the director general would not suffice, and the court judgment in the present case would not suffice as a substitute to the two necessities of the provision. The second rebuttal, my lord, is with regards
Could
to
you,
environmental.
Speaker 2, could you please repeat your argument on your rebuttal? As I was
Yes,
disconnected.
certainly, my lords. So, my rebuttal is on the grounds that Section 20A, subsection 4 of the Ancient Monuments and Archaeological Sites and Remains Act says that there is a specific bar on granting any new permissions for construction in a prohibited zone, which is 100-meter radius from the protected monument, uh, except for permission through the central government or the Director General of the Archaeological Survey of India. This was added by the amendment of 2010 of the AMASR Act. I would like to pose the question to the council of the respondents, how they can, without the prior approval of these two.
Council, I just want to interfere. Don't pose the question towards the opposite council. It is the duty of the court. You just make your submissions. We
My
will pose a question later
My
on.
apologies, Your Honor. Much apologies, Your Honor. So it is my respectful submission, Your Honor, that in the case of Nahata Traders and Builders versus Private Limited versus Director General of the ASI, the court specifically said that there cannot be any delegation of authority to entities other than the central government or the Director General to grant such exemption for construction, and a court judgment would not suffice a substitute of these necessities. It is further my submission, my lord, regarding environmental impact assessment. Statutory mandates under the Environmental Protection Act and the notification of the Environment Impact Assessment dated 14th September 2006 require completion of an environmental impact assessment and obtaining environmental clearances before project commencement, and failure to do so would amount to statutory and regulatory non-compliance. It is my humble submission, Your Honor, that the current project has not has not obtained such clearances and has not completed its statutory obligations. That is, with that, I would like to conclude my submissions, my lord.
I have a question for both the counsel for the petitioners. If we allow you for the compensation, in that case, will you withdraw this petition? If we allow you for the appropriate compensation with the appropriate authority? Speaker 1 plus, please.
My lords, much obliged. My lords, I think the compensation is a very small aspect of this SLP that is there. My lords, the entire SLP is comprised that it is against whether compensation is adequate or not, I shall come to later. But the reconstruction that will happen here will concurrently be damaging the faith of millions of people, my lordship, including myself as a Krishna devotee, my lordship. That is, and in case the compensation is, let's say, given to the people of Vrindavan who reside there and are shopkeepers there and conduct their daily livelihoods there, my lords, is it adequate to destroy their temple, which is also a part, could be a part of their shop, could be a part of their home, in the name of reconstruction that will happen in through, if this is if the prayer that we are seeking is not approved, my lord?
But Mr. Counsel, if the development will come only after destruction, and the development will ease off the operations in the temple premises for mass at large. Don't
Even
you
if I
think so?
Even if I agree to that, my lords, the memorandum that has been submitted by the respondent and the corridor scheme itself proposes no, absolutely none measures that can give a comprehensive solution to preserving these alleyways, or let's say alone the elements of these alleyways, my lords. My lords, let's say if there would have been a solution that we would break or deconstruct the illegal pavements that have been made to broaden these alleyways, my lords, then then it would have been adequate, my lords.
If you
But
can
no
just,
such submission has been made, my
sorry
lord.
for interrupting, I think there's some network issue. Okay, you may continue.
No. Yeah, please continue. I heard the arguments.
My lord, that is my only humble submission, that uh, no adequate alternative measure has been here proposed that can do so.
Okay. Speaker number 2, Council 2.
Much obliged, Your Lordship. I would like to add on to my co-counsel's points by saying that the cultural fabric of Vrindavan, which supports its pilgrimage economy, will be permanently altered and irreversibly altered should the corridor project be continued. Additionally, the environmental impact onto the Yamuna River, which is a mere 300 to 500 meters away from the corridor project site, which exposes the river's sensitive ecosystems to the risks of human activity, construction debris, and encroachment of the floodplains, which threaten the environment, which threaten the quality and ecological integrity of the river itself. The river itself, my lord, has religious significance. And not only would it be ecologically damaging the environment, it will also be hurting the religious sentiments of the people of Vrindavan and Hindus in general.
My question to you, Ms. Counsel, that the economy, as we have seen in the past cases of Ayodhya, the Babri Masjid and Ayodhya, the Ram Mandir case, the redevelopment of Kashi Vishwanath, the redevelopment of Mahakal corridor, the economies of that area has boosted several times. It will help the mass over the in Vrindavan corridor. Once it is developed, it will increase the economy and benefit the people at large.
Your Honor, my humble submission is that without rehabilitation of the 500 shopkeepers that are being displaced and evicted from their livelihood, like the place of their livelihood, which have been there for decades, if not centuries, right, would amount to economic harm to the city of Vrindavan. In all of the cases that you have mentioned, adequate rehabilitation would have been made. This I am saying by pure logic and not by fact, as I have not confirmed the fact that these rehabilitations have been made in the
Then in
specific
that
project.
case, if we allow you for a compensation from with the appropriate authority and a rehabilitation plan by the state government, what will be your point of view in that case, both of the councils?
My lords,
One
I
by
would like to. I'm sorry.
one. By one.
Uh,
This question is to both the petitioner councils.
My lords,
may
I would let my co-counsel take the question first.
Yeah.
may I have the permission of the court to answer the current question?
Yeah, please.
My lords, I would like to submit that even if rehabilitation and compensation is provided, the religious tourism depends on the sacred Kunj Galis of the Vrindavan, where Lord Krishna was said to. It is believed that Lord Krishna himself performed Ras Leela and roamed the very gullies that exist today. The religious tourism furthermore depends on those specific Kunj Galis where tourists come to fall in the steps of Lord Krishna themselves, and the alteration of those Kunj Galis will amount to a reduction in such tourism. I would like to now hand over to my
Sure.
counsel.
Council 1.
Permission. of the
Much
court.
obliged, my lords. My lords, I will give a very brief answer to this question. My lords, controlled development, which is often masked as heritage destruction through incremental change, has not been, both jurisprudentially and by humane logic, has been allowed by this court. My lords, constitutional rights do not permit compromise when alternatives exist. Moreover, heritage preservation isn't merely architectural. It includes living cultural practices, which is, as my co-counsel said, is the Kunj Galiyan. And also the spatial relationship which the devotees that will come there will have with those Kunj Galiyans, and the community memory embedded in those transitional routes that will be altered. And my lord, one more addition, that these transitional routes also include the parikrama ghars, which will be destroyed by this corridor scheme. My lords, functional improvements, which is the whole aspect or the aim of this corridor scheme, they must respect these intangible heritage elements which cannot be sacrificed for the engineering efficiency, my lord. That is my humble submission, my lord.
But Mr. Counsel, it will restrain the state governments and the law enforcing agencies to provide security as well as the medical emergencies in that case, as the lanes are really narrow. Even not even a fire brigade or a ambulance could travel in that place.
If I may have the permission of the court to answer. My lords, in an absence of consultation that has not been done, I completely agree with my lords when they say that there is an absence, there is a need for infrastructural development. But my lords, there, according to the petitioner asserts that there is also a need for this court to form a committee which can proportionately then, effectively then, apply these reforms that will be formed by that committee in itself, which is absent in this case, my lord. What is present in this case is an arbitrary issuance of a mandamus, which shouldn't have been there in the first place, my lords. That is my humble submission, my lords.
Sure. Rebuttal from the respondent side.
Indeed, your lordship. Your lordship, as the first question from the petitioners that deals with basically the judiciary's intervene. So, your lordship, in the case, as they mentioned, the Keshwananda Bharati versus State of Kerala, which also talks about the judiciary's independence with the rule of law and the separation of powers, is the basic structure of the constitution. Your lordship, this case also talks about the independence of judiciary. So, your lordship, it is in the favor of the state. It is in the favor of the mandamus writ issued by the Honorable High Court of Allahabad. And your lordship, the second question is basically related to the right to life, where the waiver of right to life on the right to livelihood is because of Article 21 provides right to life as an absolute right under Article 21 of the Constitution of India. Your lordship, my another answer to the petitioner side was that will be that duty. This is the duty of the state. This is the fundamental duty of the state under Article 48 of the Constitution of India as directive principle of state policy to protect the heritage, to protect the environment also. Your lordship, to protect the culture and promote the culture. Your lordship, I also want to mention that if the respondent council is talk about the Sri Krishna's Ras Leela and the violation of culture, then the council wants to give an example of the Ram Mandir in Ayodhya. Your Lordship, at the time of Vanvas of 14 years of Lord Sri Ram, steps forward towards the south, then Sri Lanka, then towards the Sri Lanka, it doesn't mean that the state change and alter the culture. In every step forwards towards towards different states by Sri Ram, your lordship, the state develop that particular states, that particular places where the Sri Ram steps forward towards the south. Your lordship, basically it means that there is no violation of Article 25 and the 26 of the Constitution of India. Your lordship, I also humbly submitted that under Article 25, clause 1 of the Constitution of India, it is written that subjected to the public order, morality, and health,
Sorry for the
and to
interruption,
other
but
provisions.
time is already ended up for the speaker one.
Indeed, sir.
Speaker 2.
Indeed, Your Lordship. The Speaker 2 is having only one question for the rebuttal. In the whole argument from the petitioner's side, they have reached the Honorable Supreme Court through SLP. But in today's whole argument, they have forgotten to mention the jurisdiction, the whole soul of this matter, the statement of jurisdiction by which they are coming to this court for the justice. They have all missed this fact to state the jurisdiction and address the bench for the same. This is all from the council too.
But Mr. Counsel, they have answered the jurisdiction at the first place. How the Article 136 will lie? And
No, but
is
sir, it's
does
not
it
mentioned
really
properly.
important to? Okay.
This
Then
started
how the
there
state
from
will,
issue 1.
but how the state
Pardon, Your
will
Lordship,
in
I
this
am
case?
audible?
Yeah, you are audible. Do I am audible?
Yes, yes, Lordship. Indeed, Lordship.
But in this case, how the state will justify their acts of demolition and disturbing the lanes and tranquility of the public and religious place? It will completely disturb and the public place and the peace. It will also disturb the peace also of that area if you go for the demolition. The
Sir, here,
compensation will not satisfy the public, na? In this case, compensation is only for the people who are residing in that area. But what about
indeed,
the
Your Lordship.
religious sentiments of the persons who are not residing in the premises of which come under the Jamuna, this Vrindavan corridor?
Indeed, Your Lordship. The whole purpose for the
They also have a religious faith towards the gully, these lanes of the, as the petition stated. Everyone has a religious faith over the Kunj gullies of the Vrindavan. They have a religious faith over there, which
Indeed,
lies. And if we are going to order it in your favor, the public will protest in that case.
Indeed, Your Lordship. I humbly submit that the purpose for the demolition is not to prevent, not to the collision with the not to collide with the fundamental freedom of practice of religion, Article 25. It was the meant as it is a process. So for the stoppage of the stampede.
If you are comfortable in Hindi, you can continue in Hindi also.
Indeed, Your Lordship. The whole sole purpose for the demolition is not to break the heritage.
Okay.
It was a stampede, and it is a trend. It is a trend. It is not only a single incident where we have seen this type of threaten to life. Even in this case, it was mentioned in the statement of fact from both the sides that the Kunjgalis is a part of heritage. We agree. But the whole purpose there is mentioned that 50 lakhs devotees visit annually. To manage that particular crowd, a proper infrastructure, proper exit, proper medical requirement should be there. As we have a great example of Kashi Vishwanath, Golden Temple, they have a proper space for management of crowd. But here in Baki Bihari Temple, indeed the narrow lanes have a significance of heritage and respect for the culture. But to manage a whole crowd, it's the duty of the state to issue the schemes as a absolute Article 21.
But the state does not have come up with a plan of how they will protect the Yamuna River, which is just 100 meters away.
So it is 300 to 500 meters away.
Okay, let's take up how it's 500 meters away also. But it will harm the construction construction in that area will harm the environmental piece over there, environmental area permissions, which the state has not taken up till date.
Indeed, your lordship, the question is valid for the environmental purposes. But in the plan, the scheme, it does not mention anyway that it will go through it will cover the flow. It will cover the Yamuna River. It is not mentioned in the facts that a particular Yamuna part will be used for construction. It is not clearly mentioned. The only scheme is showing, the only particular part of scheme is.
Sorry for interruption, but the time has ended up, sir.
Let's proceed to the concluding arguments. Petitioners?
My lords, if I could give a very brief answer of the rebuttals that were posed.
In your concluding argument, you can state that?
Yes,
if
yes.
possible.
Certainly, my lords. My lords, the concluding arguments would be divided in a way that my co-counsel would be focusing on the prayer and I would be giving a very brief answer.
Okay.
Much obliged, my lords. My lords, although I could not understand the question, where the question was in the second speaker's argument who posed the questions first, the only questions that I could get to was that of judicial review and basic structure, my lords. My lords, since we have proposed basic structure doctrine and they have talked about judicial review, my lords, I would like to state that there is no conflict in those. Both separation of powers and judicial review are basic features. However, my lords, judicial review does not mean judicial governance. My lords, in Keshwan and the Bharti, this courts recognize that while judicial review is essential, it must operate within constitutional bounds, my lords. My lords, the High Court crosses, in this case, from reviewing executive action to directing specific executive policy. My lords, this transforms judicial review into judicial administration, which then violates the very doctrine that both the petitioner and respondent here are claiming. My lords, to the second part of jurisdiction which was there, my lords, in first case, we would have not submitted the SLP in Supreme Court if we would have not been confiding or been agreeing with the jurisdiction of the Supreme Court. Secondly, my lords, we could not have filed it in High Court again because 115 of the CPC then bars you for filing a revision petition in High Court against its own order. That is my humble submission and answer, my lord.
If I may have the permission of the court to continue with the prayers.
Continue.
Much obliged, Your Honor. In consideration of the questions presented, arguments advanced, and authorities cited, the counsel for the petitioners most humbly submit and respectfully pray that this honorable court be pleased to adjure and declare an injunction for the continuation of the project to protect fundamental rights as conferred under the Constitution, uphold that the writ of mandamus issued under Article 226 amounts to impermissible micromanagement, uphold that the state interference is unconstitutional and amounts to a breach of fundamental rights, that the state's objectives of public safety do not justify such large-scale demolition and redesign, and lesser restrictive alternatives would suffice, and that this This absence or inadequacy of public consultations does render the decision-making process arbitrary under Article 14 and declare any other relief that this honorable court may be pleased to grant in the interest of justice, equity, and good conscience. With that, the counsel for the petitioners would like to rest their case.
Okay. Counsel for the respondents. Your closing statement.
Allowed, the council wants to answer the question of judicial governance versus judicial activism or something, as the speaker one mentioned. Your lordship, the judicial governance is
Ms.
no.
Counsel, you can have a concluding argument.
Indeed, your lordship. Indeed, your lordship.
Please continue.
Indeed, your lordship. Your lordship, the council wants to end it with the prayer.
Your voices are not audible.
So the council seeks permission to state the prayer.
Okay.
Wherein force, in the light of issue raised, argument advanced, and authority cited, it is humbly prayed that the Honorable Court may please to declare that to dismiss the special leave petition filed by the petitioner as the judgment and order the Honorable Court of Allahabad dated 20 March 2023 is valid and constitutional exercise of writ jurisdiction to declare that the Baki Bihari Corridor project is a necessary, proportionate, and non-arbitrary measure to ensure public safety, which is paramount constitutional duty of the state under Article 21 of the Constitution, to uphold the order of the Honorable High Court as a justified act of judicial activism aimed to fulfilling the state neglected duty to protect the right to life of millions of pilgrims, therefore distinguish it from judicial overreach, to direct the petitioner to cooperate with the state in the expeditious implementation of the project in large public interest, to pass and any other such order as this honorable court may deem fit and proper in the interest and of justice, equity, and good conscience. And for this act of kindness, the respondent, as a duty bound, shall ever pay.
Okay.
This is our
Do you have any concluding arguments?
No, sir.
Okay. Can we end it?
Your lordship, if as we were not submitted our issue number 3, is there any question from the lordship related to any issues? If not satisfied?
No, I am satisfied.
Indeed, your lordship. Much obliged, your lordship.
We can conclude the meeting, I think. So it was nice meeting you all. It was very wonderful of all of you to present here and be so much of diligent and very focused on what you have to present. So I now request the judge, honorable judge, to kindly give a valuable feedback to the councils.
The councils were really great in this case, and all of them represented their sides with a great and force, I must say. Everyone was great, really representative. The only thing, my suggestion is towards Team 68. Team 68, you are representing the state, not the some petitioners. And in your arguments, you were going against the state. You have several times, I have noted that you 4 to 5 times you have stated that the state has not performed the duty, so the court has intervened in it. As a counsel for the state, you have to defend the state, not go against the state. I hope you got my point.
Legally, according to Moot competition, they were very much well satisfied, but applause to team number 17.
Legally, I hope you got my point, Team 68.
Indeed, sir.
Indeed, sir.
Your lordship, as we were mentioned that the judiciary has to intervene because the mandamus was issued by the judiciary is right, as we submitted that the judiciary has to intervene for the state's action for submitted the corridors project. That's why, Your Lordship, we are submitting.
But never go against the state.
Indeed,
Never
much
go
of
against
indeed,
your party, whoever it may be in future.
indeed, Your Lordship.
Indeed, Your Lordship.
Never ever submit anything. Just be silent on that part.
Indeed, Your Lordship.
You could have been silent at that point. We all know that the state has not done it right. That is the
Indeed,
reason
Your Lordship.
the Allahabad High Court intervened in the matter. Everyone from the memorial got this point. But
Indeed.
we cannot, in that case also, we cannot say that the state has gone not done anything which is against law. Because you are the defending party for the state. So over here, I have to say, it was a really tough call for me. You have represented your arguments. All four of you have represented very well. But still, I must applaud to team 17 over here. I think Mr. Arya will agree with me.
Yes, sir, very much agree. Team
Thank you so
17
much.
was wonderful, sir.
Thank you so
Team
much.
17,
In answering
I
all the
have tried
questions.
I have tried my level best for Team 17 to disengage them from their point, but they were stick to their point.
Sir, actually, I was trying to focus on team number 60, but my focus was shifting towards 17 because they were very much clear on their point.
Exactly. When I offered them the rehabilitation and the settlement, they have,
Right.
despite that, they have refused it. And they
Correct.
have pursued with their matter. That is the point what the Team 68 has to denote
Build up.
from Team 17.
Uh,
Don't worry, you will get more chances, Team 68.
But
Yeah,
wonderful,
yeah.
wonderful.
Your legal arguments were really good. Your legal representation, your response time was really good. And the judgments where you have cited is really good.
Much obliged, Your
Much
Lordship.
obliged.
Sir, if I may, sir, is there a feedback on argumentation that was made by Team 17? If any feedback could be given, sir.
It was a difficult call for me now.
I
You were
think it
good.
is not. I
You
think it
both
is not
were
the
good.
first time you are participating, right? It is not your first time.
Mine, this is my the only moot that I have done apart from this is an intra moot that was in my college of the students of the college. I have not participated in any other moot apart from this.
But your representation shows that you have been interning with some good lawyers.
Sir, actually, I was ex-intern with Mr. P.H. Parekh.
Oh, great.
Yeah.
I
If
can
any job is
understand.
available at your chambers, I would also like to come and intern there.
Sure, we will.
Thank you so much, sir. Thank you so much.
I
So
may
nice
now,
meeting you all.
I may now request all the participants to kindly leave the meeting.
Thank you so much for
Thank you
your
so much.
suggestion, Your Lordship. Thank you so much.
Thank you so
Thank
much.
you, sir.
Thank you so much for your presence.
Team 68, you must go on. Team 68,
Yeah, yeah.
you are here.
Indeed,
Yes,
sir.
sir.
Indeed, sir.
Have you interned with someone?
No, sir.
No, sir.
Go and
Currently not.
go and
Uh,
join in your next holidays. Go and intern with someone.
Indeed, sir. Indeed, sir. Sir,
You are
actually,
you
there
are
is 1
really good
month.
You both are really good representators. You just need an exposure.
Thank you
you,
so
sir.
much, sir. Thank you so much,
Thank
sir.
you, sir.
Sir, actually, there is a problem with us. Only 1 month holiday will be provided by the university. So it is very hard to engage in any internship and any
1 month is
type of
sufficient.
practice.
Don't worry about it.
We will engage with the internship
The
and we
summer
were
internship
engaged
programs.
with the internship programs already in 1 month. We on only 1 month is provided by the university, so we were already engaged for the 1 month in High Court of Uttarakhand, that is Nainital High Court, and before that we were engaged in Delhi Tisajari Court. So Only for 1 month
Next-
is
next time
the
go and,
only option for us.
Next time, go and intern with an district court lawyer in Uttarakhand. As there, I don't think so. There will be holidays in at that time with the district court.
You'll need to unlock your iPhone
Indeed,
first.
sir.
Good luck. Hey,
I
good
will
luck to you
have-
all.
Yes, sir. Thank you so much. Needed, sir.
Thank you so much.
Thank you so much, sir.
Thank you so much for your presence.
Thank you
Thank you so
once
much.
again.
You may now leave the meeting.